Hi there. So I think one of the hardest topics to answer an AO2 scenario question on is non-fatal offences against the person, and that's because it covers such a wide range of offences that it often seems like a lot to write. Also, in a scenario question, you will normally find a number of different issues going on, so even just reading the question can sometimes feel a little bit overwhelming. So I wanted to take you through, step by step, how to look at structuring a non-fatal offences scenario question in the exam. So just as a reminder, what we're aiming to achieve is 25 marks in approximately 30 minutes. You have to hit 2 assessment objectives in that question. There are 10 marks available for AO1, which is relevant knowledge and understanding of the non-fatal offences. Then there will be 15 marks available for your AO2. So that's your application of your knowledge of the non-fatal offences to a defendant in a given scenario. So we can use the IDEA acronym to help us structure our answer. So IDEA stands for identify the crime, then define the offence that we're looking at, explain the rules, particularly through the use of past case examples, and finally, to apply it to a defendant in a scenario. So I want to take you through, step by step, how to answer a scenario question using that structure. And we're going to do it looking at a particular scenario question. This scenario involves Sandra attacking her ex-boyfriend's new girlfriend, Talia. So reading through the scenario, there can be a lot going on. Your task in the exam would be to advise whether they are criminally liable for any non-fatal offences against the person. So what I want to do is take us through step by step, and this structure can be used for any similar question. First thing to do in the exam is to identify the potential crime. We need to read through the scenario and highlight wherever there has been the most serious harm that has occurred from a chain of events. So in the exam, read through every single sentence and highlight all of the offences, the potential crimes that you're going to have to discuss. Then you need to try and identify them. So what are we looking out for? If there's no touching involved, so for example, the person has said something or has done some sort of gesture like shaking a fist, waving a knife, aiming a gun, if there is no touching, then it is a potential assault. Now remember, we're just dealing with potentials at this stage. If the defendant has simply touched the victim, or they've touched the victim in a way that has left some very, very minor harm, perhaps a very minor scratch, a very minor bruise, then it is potential battery. Then you have to make some decisions, some choices in the exam. Do you think they've caused some harm? In the case of R versus Miller, they talked about anything interfering with the health or comfort of the victim. And remember, this can include psychological harm, physical harm, even biological harm, like infectious diseases. If you think it is more than minor harm, but not quite serious, then it could be section 47 ABH. Now, a lot of students seem to get mixed up with the final offence, but the final offence, there are 2 ways of carrying it out, so make sure you identify the correct way. If the defendant has caused some bleeding, aside from a little minor graze, but they appear to have broken the top 2 layers of skin, then this will be wounding. However, the case of JCC versus Eisenhower told us that is the definition of a wound, but you can still have GBH where it hasn't caused a wound. GBH is serious harm, but without the bleeding element. So in JCC versus Eisenhower, a shotgun pellet went into someone's eye. It didn't break the top 2 layers of skin, so it wasn't a wound, but clearly that would be serious harm. So for this, it could be things like very, very badly broken bones. It could be internal bleeding, fractures, things like that. The CPS charging standards give some guidance when it comes to the Crown Prosecution Service prosecuting real life defendants, and can provide as a guide for help in the exam. In the exam, often there is maybe a few different offences the person could charge with. So it might be ABH, some people might argue it's GBH, and often examiners will credit different trains of thought. So what you need to do is go through your scenario and then label what you think the potential offences will be. This gives you the opportunity to group potential offences together. So for example, if there are multiple cases of potential ABH, you might want to talk about all of those together. So we've actually done the hard work, believe it or not, in trying to identify the correct offence. The rest is simply explaining and reasoning through our decision. So the next thing that we have to do is definitions, defining the offence. And this is where our AO1 really comes into play. So a good starting point for any essay is just a definition. Try and define the actus reus, the mens rea, and the sentence of each relevant offence. That's important. So for example, if there is no sign of any wounding in the scenario, you do not need to define wounding. However, if you think there's a potential assault in there, make sure you're defining assault. So a simple way of starting the essay is assault is, battery is. You should also be aware of the different sentences and perhaps even the classifications of each offence. Do you know which ones are summary? Do you know which ones are indictable? Do you know which ones are triable either way? And that's good revision as well for your criminal courts. Once you've done that, you must then explain the law. So this is your AO1 revision. And this is your chance to really show off with case examples. For every potential crime, you should break down its actus reus and mens rea to explain the key words using case examples. Now, how many case examples? That's a difficult question to answer. The correct answer is more than your competitors. So as a minimum, try and get at least 3 cases, but the more the better, as long as you can fit it in about 10 minutes of AO1 writing. So for example, if you think there's a potential assault in there, you need to be talking about what words or gestures would count. What is the court's situation and stance on words? What are negating words, as seen as the case of Tuberville versus Savage? What does fear or expect or apprehend, what do those words entail? When is immediate? When does immediate end? What is classed? And you might bring up the case of Smith versus Woking, for example. So this is your chance to show the examiner your AO1 knowledge, including case examples. And you need to do that for all of the relevant offences. Then you need to apply the information to the people in the scenario by deciding if both the actus reus and the mens rea is satisfied. Mens rea is usually the hardest. So what I've done here is just gone through a breakdown of key mens rea questions. Apply the actus reus, and then for assault, your question to ask yourself is, do you think the defendant intended to make the victim expect immediate unlawful force? Now remember, intending something is where it's your main aim. We saw that in the case of R versus Mohan. So is it your main aim to make the victim expect force? Or perhaps alternatively, you thought the defendant was reckless as to whether the victim would feel this way. Recklessness, as we saw in the case of R versus Cunningham, is about the defendant realising there's a risk this could happen, but they go ahead anyway. They don't stop, they still decide to do it, knowing that there was a possibility this outcome could occur. If it's a potential battery, apply the actus reus, and then for the mens rea, ask yourself, did the defendant intend to apply force to the victim? Was that their main goal in what they did? Did they know they were doing that? Did they want that to happen? Or were at the very least, were they reckless? Did they realise the risk and carry on? This is where it starts to get a little more complicated when it comes to the Offences Against the Person Act 1861. For ABH, apply the actus reus, so did they cause some harm to the victim? But you ask the question the next offence down. So all you have to decide is, did the defendant intend the assault or battery that led to the harm, or were they reckless about causing an assault or battery? Remember, there is no need to prove here that they wanted to hurt. And this was demonstrated in the case of R versus Savage. So in R versus Savage, she wanted to pour a drink over the woman she was arguing with. That would be a battery, applying unlawful force via a drink. However, she dropped the glass. Now that caused some harm, obviously. She argued that she never wanted that she never thought about that. That is not the question for the mens rea of ABH. All we have to prove is that you intended or were reckless as to an assault or battery, which she clearly was. Wounding and GBH. Now you've gone through the actus reus. Did they either break the top two layers of the skin, or did they inflict or cause serious harm to the victim? Those are actually quite straightforward questions. What's difficult here with wounding and GBH, and the rules are the same for either, is the mens rea question. And the key question to be asking yourself when you read the scenario is, do you think the defendant intended serious harm or a wound? Was that what they wanted? Was it their main aim? If you think yes, then the person will be charged with Section 18. So that will be Section 18 GBH or Section 18 wounding, depending on what they caused. That leads to a discretionary life sentence because this is clearly a very dangerous person. They wanted to cause serious harm or bleeding, and they did it. However, if you think, based on the facts in the scenario, you think, actually, I don't think they meant serious harm, I think they just wanted to hurt them a bit, it just got out of hand and caused serious harm or bleeding, then the person will be charged with Section 20 GBH or Section 20 wounding. Now remember, this also includes reckless behaviour. So if you think the person was reckless as to some harm happening and then something really bad happened, that would include here. Now you need to conclude overall. You don't actually need a conclusion at the end as long as you conclude throughout. So what I wanted to show you was an example answer of how you would go about writing this. So you do the AO1 first, and then you can either go through the scenarios in chronological order and pick out the offences, as I've done in my example, or you can group the different ones together. So you could talk about all the assaults first, then all the potential batteries, then all the potential ABH and so on. Either structure is up to you. The key is to pull out the information of the scenario to back up and support your answers. So if you know the offences and their definitions, you should be able to have an idea of what to write in the exam. Thanks for watching.